Yeah, good afternoon and a very warm welcome to our expert panelist, Sudhakar sir, Narayan sir, Majumdar sir, masters of the subject, guru of the subject. We really grateful to you all, sir. And am I audible, na?
You're a bit audible.
Yeah, good afternoon to all the participants and all my friends. And I welcome you all in this fifth webinar session of Secretarial Standards Week, being celebrated by the ICSI on the theme, Decoding the Secretarial Standard and Guidance Note. Today we are decoding the aspects, guidance note or prevention of insider trading. Friends, we are celebrating this week as the Secretarial Standard Week under the guidance of our President Devendra Deshpande ji and Vice President Manish Gupta ji. Dear friends, we have received an overwhelming response in this entire webinar session of the Secretarial Standard Week, and in each and every session, around 6,000 to 8,000 participants have joined and benefited. The all credit goes to the quality of guidance note, expert knowledge of the expert panelists joined in the earlier webinars, which makes it more interesting for participants to decode such practices, to decode such a guidance note. Friends, our panelists who are the architect of this decoding, who are the architect of this promoting this guidance note, and hope all the corporates and professionals are getting benefited with this guidance note and with this deliberation. Friends, on the topic for today's session, I wish to share the brief background as to why this guidance note has come up by the ICSI, the prevention of insider trading. Normally we say it PIT. Friends, insider trading is a very sensible issue. So SEBI, stakeholders, corporates, everyone wants it to be very fair and transparent. SEBI also wants that every trading should be fair, transparent, and fair enough. For confidence, trust, and integrity in the securities market, SEBI has come with various initiatives to ensure fair market conduct of the SEBI PIT regulations. The guidance note on PIT issued by the ICSI also supplemented with the specimen format of disclosures required under the PIT regulations. It also includes important case laws on the subject, and it also includes the recent amendments introduced time to time. Friends, in today's session, we are going to deliberate upon this very important and sensitive issue, and we are having a very expert panelist who are the masters of this subject, Sudhakar sir, Narayan sir, and Majumdar sir. It's my pleasure to introduce our expert panelist in brief, sir. Let me first introduce CS Dr. Pritesh Majumdar, sir. He is also a member of our institute. He is Master of Law and a PhD in Law from University of Mumbai. His area of research was corporate governance. He is with DSP Group for last 15 years, and he currently heads the legal and compliance function at DSP Investment Managers. Dr. Majumdar, sir, we welcome you once again in this panel discussion, sir. Then CSS Sudhakar, sir. Sudhakar, sir, entire country, entire CS fraternity, entire corporate house knows you, sir. CS Sudhakar, sir, is a fellow member of ICAI and ICSI both. He is also a qualified secretary under ICSA UK and a law graduate from Mumbai University with over 3.5 decades of wide spectrum of experience in legal, secretarial, finance, and accounting fields. Since 2005, he is working with Reliance Industries Limited, one of the most grown industry in the country. Mr. Sudhakar is also a member of Secretarial Standard Committee of our institute. He is vice chairman of expert group of Secretarial Standard of our institute. He was member of Vision Core Group and Vision Implementation Group of ICSI. He is member of Corporate Affairs Committee of PhD Chamber of Commerce and Industry. He is faculty in various places like IOD, NISM, KJ Somaiya Institute of Management, ICLS Academy, IIT, and many more. And he is regularly addressing to our institute and to ICAI, ICMAI, and several chambers of commerce and industry. Sudhakar sir, we welcome you once again in this panel discussion, sir.
Thank you very much, sir.
Now, sir, CS Narayan Shankar, sir. CS Narayan Shankar, sir, is a member of our institute and has over 25 years of rich experience in the field of corporate law and legal affairs. He joined Mahindra & Mahindra in the year 2001 and is currently the Executive Vice President and Company Secretary of Mahindra & Mahindra. He is also a director on the boards of various Mahindra Group of companies. He is member of expert group of secretarial standard of our institute and has been a member of various committees set up by the MCA and SEBI. He has played a very influential role in raising the corporate governance standard of Mahindra & Mahindra to its current level. During his stint in Mahindra & Mahindra has won twice the honored with the Golden Peacock Award for Best Corporate Governance and Best Governed Company Award twice from ICSI. He has represented the industry on several occasions with Ministry of Corporate Affairs, SEBI, Depository to take up the issues faced by the industry time to time. So friends, we will take up these sessions by all the three panelists, and I hope all the three panelists will discuss their own issue in approximately 20 minutes each. Then we will go for question and answer session. So we will start the session with CS Narayan Shankar, sir. Sir, over to you, sir.
Sandeep, Pritesh had suggested that he will take definitions. So what we can do, we can start with Pritesh, who's taking the definitions. Okay. Thereafter, Sudhakar is going to take 3, 4, 5. Okay, and sir. Then I'll be coming at last.
Okay, sir.
Okay, Pritesh, over to you.
Is this shared?
Yes, sir.
Yeah, thank you. Is the screen visible?
Not yet.
Yeah, just wait.
It's coming up. 1 minute. Yeah, now it's come.
Okay. So, first of all, at the outset, I thank the Institute of Company Secretaries of India for giving me this opportunity and platform to get into this webinar on a very interesting topic on prohibition of insider trading regulations and the guidance note issued by ICSI. So thank you and a warm welcome to all the attendees. Okay, so first, before jumping into the definition, I would start with a brief introduction as to what is insider trading. So insider trading in normal parlance is trading in securities of a company by persons who are in management of the company or have close proximity to them on the basis of unpublished or undisclosed price-sensitive information, which is not available in public domain. So it should be noted that insider trading based on any unpublished price-sensitive information is not only unethical, but also illegal. Insider trading is a market abuse. Insider trading is not only a tort, that is a civil wrong, but it is also a crime. Now, the SEBI has issued Prohibition of Insider Trading Regulations 2015, which are effective from 15th May 2015, by repealing the erstwhile SEBI Prohibition of Insider Trading Regulations 1992. And the Institute of Company Secretaries of India has also issued a very comprehensive guidance note on the topic, which is based on the regulations, decided cases on the subject and FAQs thereon, and even the informal guidance which are issued by SEBI from time to time. So first is the definition of compliance officer, which is given by Regulation 21C. So a compliance officer means a senior officer. So the way it has been defined is that a person who is a senior officer reporting into the board of directors or to the head of organization if there is no board of directors. And he should be financially literate. Now, the term financially literate is also explained in the definition itself. Financial literate means a person who has ability to read and understand financial statements, that is balance sheet, profit and loss, and cash flow statements. And the person should also be responsible, who should be able to appreciate the requirements of legal and regulatory compliances under the regulation, and shall be responsible for compliances of the policies, procedures, code of conduct, and adherence to the rules made by SEBI and the circulars issued by SEBI from time to time. Now, a few questions and decided cases were like, can a senior person, say a CFO or a CS, who is not reporting into the board of directors, act as a compliance officer? The answer is that functions and responsibilities of a compliance officer are being defined, and a company may at its discretion appoint a senior officer as a compliance officer, but that person has to report into the board of directors or into the head of the organization. So that's very important. And second, can a company appoint more than one person as a compliance officer under the code? Yes, the company can appoint more than one person. However, both shall be jointly and severally responsible. So basically, under these regulations, every issuer, every market intermediary need to appoint a compliance officer. It is intended that such compliance officer read and understands the basic financial statements so as to understand the impact of UPSI on price discovery of security market, so that he is able to administer the regulation in a very informed manner. Next, the definition under regulation 2(1)D about the connected person. Now, the definition is being split into two important limbs. First, it defines means a person who is or during the last 6 months prior to the concerned act is associated with the company by reasons of frequent communications with the officer or through contractual, fiduciary or employment relationship, and who has an access to UPSI or is reasonably expected to allow such access. So that is the first limb of connected person. The second limb is a deeming fiction. Basically, it says that it lays down certain categories of relationship or connected person, which are deemed to be connected person. Now, what are they? They are like holding companies, associate, subsidiary, or intermediary defined under Section 12 of the SEBI Act, or official of a stock exchange, clearinghouse, corporation, member of board of trustees of a mutual fund, member of board of directors of an asset management company, and employee thereof. So these are all deemed to be connected person. So it should be noted that a connected person is one who has connection with the company and is expected to put him in possession of a UPSI. Even immediate relative, which is a defined term, which we'll again see, of such person are also presumed to be connected. But such presumption is a deeming fiction, as we discussed, and it can be rebutted also by facts. And that's how both the sub-definition of the main regulation has been articulated. Now, there are 2-3 case laws, very interesting case laws on the subject. One was in Srinivasa Raju versus SEBI. The Supreme Court had held that non-executive directors are persons who are not involved in day-to-day affairs of running of the company, and hence they could not be reasonably expected to be aware of any UPSI of manipulation of books of the company. And similarly, in Deep Industry Limited, SEBI interestingly had ruled that even liking several photos on social media, such as Facebook pages, could establish association and hence could be deemed to be a connected person. Next, on a SpiceJet case, there was a connected person and a brother of the connected person, both traded in a security during the UPSI period. And the brother claimed that he is financially independent and he never consults his brother while taking any trading decisions in security. However, SEBI said that looking at the trading pattern and facts and circumstances of the case, he is deemed to be a connected person. So it's actual as well as the deeming fictions depending on facts and circumstances where a person can be deemed to be connected person. Next, generally available information. Now, generally available information has been defined, means information that is accessible to the public in a non-discriminatory basis. So generally available information is basically an antithesis of what is the unpublished price sensitive information. Now, information published on website of a stock exchange could be generally available information. Similarly, research reports may be available for a price, but so long as their research is available to purchase by clients without discrimination, the fact that it has to be paid for would not make such access a discriminatory, and hence such reports could also be deemed to be a generally available information. However, speculative reports in print and electronic media shall not be considered as a published report. So that's one has to always keep in mind. And interesting case on this was a Shruti Vora case where message floating on WhatsApp group were being taken as not generally available because they were available on discriminatory basis. However, in the same case, when the case went on appeal, the tribunal said that UPSI is, the person who receives the information should be able to understand it's a UPSI. However, we are not getting into that detail, but even SEBI has taken in the past a strict sense that information floating on social media platform, that those persons can also be booked as trading basis information which is not generally available, because there still remains an asymmetry of information there because it's available only to certain select people. Next, coming to the important definition of immediate relative. Now, the regulation defines the term immediate relative and not relative. Relative is defined under the Companies Act, but here it is immediate relative. It means spouse of a person, includes parent, sibling, and child of such person, or the spouse, any of whom is dependent financially on such persons, or consult such persons in taking decisions relating to trading in securities. Now, it should be noted that spouse, irrespective of whether financially independent or not, or consult such insider while taking trading decision, is deemed to be an immediate relative. However, such fact can be rebutted by bringing facts to the notice of the regulator, but spouse is deemed to be an immediate relative. Also, it should be noted that immediate relative of a connected person too becomes connected person for the purpose of these regulations. Next is insider. Now, insider is again defined in two ways. It means a connected person, which definition we just discussed, and it also means a person who is in possession of unpublished price-sensitive information. Now, since generally available information is defined, it is intended that anyone in possession of unpublished price-sensitive information should also be considered as insider, regardless how one comes in possession of such information. So basically, this definition is intended to bring within the reach any person who is in receipt of a UPSI. Next, Regulation 2(1)I defines the term securities. It says that securities shall have same meaning assigned to it under the Securities Contract Regulation Act 1956 and modified thereof. The only exception given is units of mutual fund, which was earlier not available. However, 2015 regulation says that carves out an exception that units of mutual funds are not securities for the purpose of PIT regulation. Now, let us also step back and understand how the word securities has been defined under the Security Contract Regulation Act. So it says that securities includes, first of all, the definition is an inclusive definition, and it includes shares, scripts, stocks, bonds, debentures, derivatives, and units and other instruments issued by collective investment schemes to its investors. So anything which is marketable becomes security for the purpose of Security Contract Regulation Act, and hence it becomes security even for the PIT regulation. Now, interestingly, even for private limited companies which have issued their debt securities, and they are listed, then they are also covered under the PIT regulation, and the PIT regulations are applicable on such listed debt securities. Similarly, trading in ADR, GDR by employees of Indian companies who are foreign nationals is also covered under the PIT regulation. Next is again a very important definition, which is trading. Now, trading, again, it says means and includes subscribing, buying, selling, dealing, agreeing to subscribe, buy, sell, deal in securities. So if you split the definition, it covers both the actions. First action, where there is a direct consideration involved, like buying, selling, or subscribing. So that is also trading, and where there is no consideration involved, like, for example, pledging, gifting, or transmission, even that is dealing, and that dealing is also being taken within the broad ambit of the definition of trading. So stock lending and borrowing constitutes trading for the purpose of PIT regulation. Trading also includes creation, invocation, revocation of pledge, and gift, as I mentioned earlier, is also means dealing, and hence trading for the purpose of PIT regulation. Next is what is unpublished price sensitive information. So that has been again, explained, and it says that something which has impact on the price, for example, financial results, dividends, change in capital structure, merger, demerger, acquisition, delisting, such proposal are also unpublished price sensitive information, and anybody trading basis such information has committed the breach of PIT regulations. Now here I would like to discuss few cases. In Divi's laboratory case, it was held that removing of sanction by FDA on facilities of pharma company is a UPSI, and anybody who has traded basis that information, and if he is an insider, then obviously he has breached the PIT regulation. Similarly, Mannapuram Finance Limited case, it was held that booking of losses due to change in law, in this case, the RBI norms relating to loan to value ratio was changed, and basis that losses were booked, even that information becomes an unpublished price sensitive information, and any trading done basis that information by an insider is being taken as a trading done by insider, breaching this PIT regulations. Similarly, in another case of New Delhi Television Limited case, a tax demand was also during a final assessment of the income tax was also constituted a UPSI. So this is how UPSI has been defined, and these were the certain cases which will help us to understand the regulatory intention, the regulatory mindset of the in such circumstances. So that's about it. Thank you.
Yeah, thanks, Majumdar sir. Thanks for your kind deliberation, and the much and more beauty of your deliberation is to connect cash flow every time. So the participant can understand this regulation easily, sir. Sir,
Yeah.
now I would like to request Sudhakar sir to please address, sir. Sudhakar sir, over to you, sir.
Sudhakar, you're on mute. You'll have to unmute.
Yeah. Thanks very much, Narayan. Thanks very much, Sandeep, for the warm introduction of all of us. And I once again take this opportunity to express my sincere thanks and gratitude to President ICSI and the entire council for taking this excellent initiative of organizing this Secretarial Standards Week. In fact, earlier we used to have a complaint against our fraternity, our own colleagues. And we had a feeling that at the expert committee that the amount of importance what the standards and the guidance notes have to receive were not receiving it. And in fact, the kind of participation which is happening right from Monday onwards till date, on an average of about 8,000 participants per program. At least in my 35 years of professional experience, I never saw any kind of webinars or conferences or conventions having this kind of participation. The kind of zeal and the enthusiasm what our colleagues are showing, the company secretary colleagues, this is giving us a lot of encouragement and motivation to further work hard and to bring good guidance notes and standards wherever they are so required. In fact, as far as the guidance notes are concerned, all our colleagues, the participants know that there are 4 guidance notes are there, and each and every subject has its own unique importance and have unique complexity of the subject also. Out of all the guidance notes, according to me, the most complex subject which we have dealt with is PIT regulations, that is prohibition of insider trading regulations. A very complex subject because in the regulations itself is very complex, and each and every word, actually every law is having its own nuances. But prohibition of insider trading regulations is entirely a different ballgame. Because though, in fact, Pritesh has explained the definitions in such a simple manner, but when we start understanding and implementing these definitions, each and every word we have to interpret, each and every word we have to understand that. In fact, to my knowledge, this is the regulation, which is very, very complex, apart from other, maybe some takeover regulations or something like that. In fact, I must say that and acknowledge there are 2 people who worked very hard as far as this guidance note is concerned on PIT regulations. One is Makarand Joshi, who is the convener of this when we brought this guidance note, and another one is Narayan Shankar, who is my co-panelist here. In fact, the amount of hard work Makarand and his team has taken, apart from Narayan and his own team also, they culled out all the informal guidance notes of almost for the last 2 decades, whatever were there and all they have culled out all the things. After that, then we had a discussion that only if we are just bombarding the people who are going to read the guidance note with all these things, it is not correct. So the relevant portions are to be culled out again and to be incorporated at the relevant places. This is not such a small exercise. In fact, the regulators have appreciated our guidance notes, and I have been told that while they are deciding some kind of cases also, sometimes they are taking the help of our guidance note also. That itself is an acknowledgement of the importance and how the subject has been dealt with in this guidance note. We must acknowledge the efforts of Makarand Joshi as well as Narayan Shankar also as far as this particular guidance note is concerned. With this, I have a small presentation. I'm going to deal with Regulation 345 and rest of the entire thing. In fact, Sandeep ji, you told us gurus, but Mahaguru is Narayan Shankar only here. In fact, I am not at all a guru as far as this particular subject is concerned. Mahaguru is here. He is going to deal with much more than what we are going to deal with. However, having said that, whatever my understanding is there of the subject, I am going to deal with that. Just 1 minute. Yeah, I'm sure that you are all able to see my presentation.
Yeah, we are able to see Sudhakar very clearly.
Thank you very much, Narayan. As usual, let me put the disclaimer that whatever the views I'm expressing, these are my personal views. Nothing belongs to the organization in which I am employed. At the same point of time, I am a member of SSC as well as expert committee, and my views are not necessarily of SSC or expert committee views. The transparency increases credibility and accountability. That Park One-Soon has mentioned about that. And the same is essential to instill confidence, trust, and integrity among us, the investors in the stock market. The most important thing for the success of the stock market is that the trust and the integrity of the players who are there in the stock market, and to instill that kind of a confidence. The credibility and accountability is very, very important, which will be the outcome of the transparency. And to a large extent, as far as the PIT regulations are concerned, that whatever the transactions or dealings are there, they are to be transparent and they are to be disclosed as per the requirements. SEBI has taken various initiatives to ensure that integrity of security market and the PIT regulations is one of such initiatives which SEBI has taken. Prohibition of insider trading, as I was mentioning, is a very complex subject. and it requires an intense diligence from all the concerned to ensure its effective implementation. In fact, it is I think to the best of my knowledge, it is the regulation wherein everyone, whether they are employed in the company, they are not employed in the company, whether they're connected with the company or they're not connected with the company. Sometimes it may be a stranger to the company also, but if he is having some kind of an unpublished price sensitive information, which has fallen in his hands, and he deal with that, he may be taken to task as an insider also. Because the definition of connected persons, definition of insider is so wide. Anyone and everyone who got that unpublished price sensitive information by whatever the means it may be, he may be taken to task as insider. Bit regulations by nature, they are prohibitive unless until they're exempted and relaxed. I always say that whenever we are handling the moment you are a designated person or you are a connected person, you have to be very, very careful with all your dealings, because it is nothing less than playing with a fire. So the moment a person is designated, he has to take an extra interest to understand what he can and what he can't do, and whatever he can also subject to what kind of relaxations and regulations, compliances he has to do that. That is very, very important. Onerous responsibilities have been imposed on the compliance officer because most of our colleagues, our company secretaries are the compliance officers. We have to understand that the onerous responsibilities have been imposed on the compliance officers, who have to have deep understanding of the subject while handling this particular responsibility. In fact, according to me, handling all other laws is one side, or handling bit regulations is on one side. That is how the compliance officers have to deal with. Because the responsibility of the compliance officer, whether it is window closure, whether it is giving pre-clearances, whether it is giving contra-trade clearances, and similarly when the disclosures comes, or every aspect of the compliances have its own nuances, and the compliance officer is to be very, very careful. In fact, when the window is supposed to be closed for whatever the reasons it is, if the compliance officer has not closed the window, he will be held responsible, and severe penal provisions will be triggered there for that. So insider trading is primarily trading in securities of the company based on the unpublished price sensitive information. And the governing rules as far as the enforcement jurisdictions and enforcement mechanism, it differs from country to country. As mentioned earlier, this since again and again, why I'm saying this thing is because I myself felt several times that despite your repeated what's called as the study and thorough study also, today if you read that, it looks like one thing, and tomorrow if you read the same provisions and the same thing, it looks different completely. So that's why it is a very, very complex subject. The compliance officer should not take it as a child play and should not approach this particular subject like any other subject, because of the responsibilities what have been entrusted upon the compliance officer. Thorough understanding of the subject and the implementation of robust procedures. Pardon my this thing, there is this small spelling mistake. It is not FO, it is OF. Robust procedures are to be introduced in the company while making this kind of compliances. These are the most critical two things as far as the compliance officer is concerned. The guidance note of ICSI on bit regulations, it enables and facilitates the compliance officer for the effective and efficient implementation of the bit regulations. Now, what are the responsibilities of the compliance officer? He should be financially literate. In fact, as mentioned by Pritesh, financially literate is capable of appreciating the requirements of legal and regulatory compliances. He should ensure that the policies, procedures are complied with, as well as the records are maintained. Audit trail is a very, very important fact when you are maintaining the records, because at any point of time, the investigator comes for any kind of inspection or investigation. The maintenance of records is not itself sufficient. You should be able to establish that the policies, procedures are followed, as well as the records are maintained the way they are supposed to be maintained. Monitor adherence to the rules for preservation of unpublished price sensitive information. This is another important thing, is that how you are preserving the UPSI and what is the mechanism of that. And that is also again the same thing. Merely doing the thing is not important. when you have to establish that if you flawed at that point of time, then obviously it will not be appreciated. To monitor the trade and implementation of the codes, to give pre-clearances, another important thing of giving the pre-clearance, it is the responsibility. Obviously, whenever you are the person who is the gatekeeper, you are the person who is the conscious keeper of the organization, and you are the person who is allowing the designated persons to go and trade. That means you are putting your neck into the nose. So one has to be very, very careful here also to ensure effective and efficient implementation and compliance with the regulations. Regulation 3 prohibits the communication or procurement of unpublished price-sensitive information. Both the ways it is not only, that means neither you can give the information or you can get the information. Anything which is unpublished price-sensitive information, if you are communicating to somebody, he may be your employee, he may be your colleague, he may be your director, he may be your CEO, CFO, whoever it is. But from your side, if you are communicating anything which is unpublished price-sensitive information, per se it is prohibited unless until it is permitted. Same is the case with procurement of information also. You cannot go and start craving for the information from your colleagues also unless until it is permitted. So where it is permitted, this is the exception what is provided is that for furtherance of legitimate purposes. So that means if you are communicating or you are procuring the unpublished price-sensitive information to furtherance of the legitimate purpose. What is the legitimate purpose? I will come a little later. So that means if it is for legitimate purpose, it is permitted. It is not prohibited. Then performance of your duties, whatever your duties are there, while in the process of performing your duties, you are communicating or you are procuring, no issue. While you are discharging your duties and the legal obligations, at that point of time also, if you are able to establish that you are now communicated the information or you are procured the information for legitimate purpose, for furtherance of the legitimate purpose, for performing your duties while discharging your legal obligations, there is no issue. Now, the term legitimate purpose has not been defined on the PIT regulations. Because of that, what happens is it is open for various interpretations. In fact, Vishwanathan Committee, based on which actually 2018 amendments have come, they were of the opinion that it may be difficult to unequivocally define such term that is legitimate purpose. So what they said that on the recommendation of this committee, the PIT regulations have been framed in such a way that the board of directors have to frame a policy for determination of legitimate purposes as a part of its code of fair disclosure and conduct, which is envisaged under Regulation 8. That means what is a legitimate purpose for which you can communicate or procure the information or not, there should be a policy for that particular thing. Legitimate purpose shall include sharing of unpublished price-sensitive information in the ordinary course of a business. That means the first and primary thing for sharing that information, one of the legitimate purposes, it should be in the ordinary course of business, and that even if that information is shared also, though it is in the ordinary course of business, it should be only on need-to-know basis. That means whatever the amount of information it is required by the other person, or whatever the amount of information required by you for performing your duties or discharging your legal obligations in the ordinary course of business, only that much is to be communicated or that much is to be procured. Nothing less, nothing more. Such sharing shall not be carried with an intention to evade or circumvent the regulations. That means tomorrow when you come under scrutiny and that sharing of information, it is established that information sharing has taken place just to circumvent the regulations, obviously you will be held to task. Legitimate purpose would entirely depend on the specific facts and circumstances of each case. But primarily, there are the following factors which shall be considered. Number one, sharing should be in the ordinary course of business. As I told you that, again, on need-to-know basis only. Despite the fact it is in the ordinary course of business, that doesn't mean just you communicate whatever you have with you to the other person, despite the fact he doesn't need to know that much of information. He requires only 1/10 of what you know and you are given 100% to him, that is not permitted. Same is the case while you are procuring the information. Second, in the interest of the company, So that means whatever the information you are communicating or you are procuring, that should be in the interest of the company and in furtherance of genuine commercial purposes. That means obviously it is for your business purpose. Third, sharing should be commensurate with the purpose for which the access is sought. Again, the same thing, commensurate with the purpose means need to know basis only. This I have elaborated already. Now, the recipient of the information shall be considered as insider for the purpose of bit regulations, and he should be told that, look, I am giving you this information for the legitimate purposes, and this information, because an unpublished price sensitive information which I am giving it to you, you will be considered as an insider, and you have to ensure to maintain the confidentiality of this information. You are not supposed to share with anyone unless until it is so permitted. And number two, you should not trade on stock market as far as the company's securities are concerned based on this unpublished price sensitive information. So he shall be given a due notice to maintain the confidentiality and not to trade on the securities of the company based on this information. A confidentiality agreement may be entered into with regard to the confidentiality of information shared or being shared in future. Such sharing of information, it should be entered into the structural digital database maintained by the company. What is structural digital database? We will again discuss about that. So Regulation 3, Subregulation 5 provides that it shall be ensured that a structural digital database is maintained by all the listed companies. This database shall contain the nature of information, that unpublished price sensitive information. What is its nature? The name of the persons who have shared the information. That means from the company side, who are all the people? Is it the CFO? Is it the CEO? Is it the company secretary? Is it XYZ? Who is the person shared that information? What information is shared? Then names of such persons with whom the information is shared, along with their PAN number, or if they are not having PAN, any other identifier number. That means it may be his Aadhaar card, it may be his passport, it may be any other information based on which he can be identified. So in the structural digital database, what the information is to be maintained is number one, what information you are sharing, who is sharing, with whom he is sharing. These are the three primary things which is to be there, apart from your date, on what date it was shared, at what time it was shared. All those other information is also to be there, but primarily this is the information what should be recorded. Such database shall not be outsourced and shall be maintained internally with adequate internal controls, checks and balances. That means you cannot ask your R&D agent to maintain this structural digital database for you, or you cannot appoint any outside agency to maintain this for you. This should be maintained within the company only, and that whether it is that means virtually it should be on your servers, and there should not be any kind of outside intervention as far as this information is concerned. The data punching, of course, don't need to say that it should be done by the internal people only. Internal controls and checks and balances should include the time stamping and audit trials to ensure that non-tampering of the database. That means the moment you punch something and all, the timestamp should be there and what date it has been done. If at all any kind of amendments or any kind of alterations, changes have taken place to that, there should be an adequate audit trial should be there. That means whenever any inspection or investigation takes place, audit trial definitely should be there. That means that your structural digital database what's called mechanism should enable the timestamping as well as the audit trials. Apart from the listed companies, the intermediary or fiduciaries who are getting that information, who are procuring that information to discharge their legal obligations towards the company, or to take up whatever the assignments they have taken up to complete that assignment if they procure that information, and their teammates or their colleagues are using that information, they should also maintain this kind of digital database as far as their companies are concerned. This is to be preserved for a period of not less than 8 years after completion of the relevant transaction. But though it is preserved, the legal obligation is for a period of 8 years. Considering the sensitivity, considering the nature of this, it is always advisable to maintain as long as it is possible. At the same point of time, in case of any legal issues or legal cases are pending with any kind of judicial authorities or quasi-judicial authorities, that point of time, this information is to be preserved beyond 8 years till the time the proceedings are completed. If you see some FAQs that can the structured digital database be maintained on a cloud server hosted outside India? Databases are servers which are provided by a third party. That means this cloud servers means it is maintained by a third party. It is not permitted. Software and server provided by the vendor, and the company can log in to the server, can have their own firewalls, protected passwords, etc., things. Is it permitted? Answer is no, because the server is provided by the vendor. That means it is an outsider's premises where you are going and working. Though the gate is there, the lock and key is there, but the premises belongs to somebody else. So if the software is installed on the server of the client, the company, then it is compliant. That means if the software is provided by the vendor, that software is loaded on your servers, and the vendor has nothing to do with once it is loaded on your server. Only you are maintaining your servers and all, you are going to punch your data, whatever it is at all, that is permitted. That means within your premises, something you have procured from outside, that you have taken your premises and you are doing it. Absolutely no issue. Software provided by the vendor and installed on the company server, this is I told. Digital database is to be maintained only on sharing unpublished prices and information, whether it is with outsiders only or with insiders also. How about sharing with the auditors for the purpose of audit? Every sharing shall be maintained if it is a continuous period to be maintained. That means if you are given to the auditors, then you have to say that for the purpose of the audit, this is the date of commencement and this is the date of the end. Like that, you can give it. At every stage, you don't need to make the entries. But if it is a continuous period, the periodicity may be given there. In fact, I will go to this extreme. Suppose when you are giving your financial results for the board for its approval to the directors, you are sharing that information. Even that also is to be, according to me, to be maintained in the digital structure. Sorry, this structural digital database. You have to make the entries. That means, God forbids tomorrow, if any kind of trading takes place, or any allegation or any kind of complaint, reach it to the regulator, and the regulator is giving a show cause to the company. Company should be able to identify with whom the information is shared, what date, what is the nature of that information, what is shared, with whom all the information is shared. That all the details should be able to be given. While in the possession of this information, the trades are not permitted, but at the same point of time, there is a rebuttal clause is there that designated person or the insiders, they may be able to prove the innocence by demonstrating the following legitimate circumstances. That means this trades, whenever while in possession of OPSI, per se, his trades would be presumed. Any kind of trade, when you are having this information with you, per se, it is taken as it is prohibited. But as I told you that your innocence may be proved, interstate transfer between the insiders who are in possession of the same information. That means, suppose if the CEO and the CFO is having the same information, and if they have a trade in between them, because there is nothing, no undue advantage is being taken, so that is may not fall on this prohibition. Through a block deal between the persons having the same OPSI with them, pursuant to any statutory or regulatory obligations, while you are exercising your stock options. And in case of bodies corporate, individuals having the information with them and the individuals who are trading, they're entirely different and they're watertight compartments, and there is absolutely no sharing of the information between these two people. If that is established, then it can be. Appropriate arrangements were in place to ensure that PIT regulations are not violated. Okay. Trades were in pursuit of a trading plan. Now, what is a trading plan? You will see again that. Now, another important thing of this PIT regulation, that new concept which has come is that trading plan. So, it is not as successful as it was envisaged in the beginning. Why it is so? What is this trading plan? Let us see that. The 5.1 provides trading plan. It is for the people who are perpetually in possession of unpublished price sensitive information. There are some people who are assumed to have that information. To a large extent, it is correct also. They have unpublished price sensitive information at 24/7. That means virtually perpetually till the time they're holding that position, they have that UPSI available with them. So how those people will trade in the market? So there should be some kind of a mechanism for that. That's why this trading plan is envisaged. So who are those people? Like your promoters, your CEO, CFO, company secretaries, executive directors, the head of departments. So most of these people, see the executive committee members, you can say, these are the people who are having this unpublished price sensitive information in perpetuity. So the trades, since pre-decided, in case of trading plan, you have to furnish your plan and other details are there that we will come to know a little later. So that trades are, since they're pre-decided, before the UPSI came into being, these trades are permitted. That means I am going to do next financial year or next 1 year. This is what my trading plan. This is the shares I am going to sell. These are the shares I am going to buy, subject to the, of course, bit regulations. That point of time, because he was not having any kind of unpublished price sensitive information with him at that point of time, it is permitted. Pre-clearance of trades shall not be required for if the trades are going to be as per the trading plan, because the trading plan, it was per se approved at the beginning itself, and everyone knows that what the trading plan, because the trading plans are to be disseminated to the public. I mean that it is the compliance officer who has to intimate it to the stock exchanges. Similarly, the person who submitted his trading plan also has to intimate to the stock exchanges. So since it is a public document, there is no question of again taking a pre-clearance for the trades. Trading window norms and restrictions on contra trade also are not applicable. Again, the same reason for that. The trading plans should not be used for capital market, it should not entail market abuse. And it shall not grant absolute immunity. Trading plan I have submitted, that does not mean if it is indulging in any kind of market abuse, the complete immunity is not going to be there. So by merely submitting a trading plan, the people should not take it as if it will insulate them in all the wrongdoings. No, not so. That means engineering is not to be done. Trading plans should be with an honest intent that a person who is having the unpublished price sensitive information in perpetuity, because he is to be also shown a window for his dealings in the company's securities, who he might be procuring from the market, he might be purchasing it, or he might have been awarded by way of a stock options and all. So there is a window provided to him that should not be misused. Trading plan should be for a period of at least 12 months. It should not be less than 12 months. Once you submit the trading plan, only there should be a cooling period of 6 months. That means today I am submitting, tomorrow I cannot execute the trades. Once I submit my trading plan, after completion of the approvals and other dissemination of that information, I have to wait for a 6 months period before I execute my first trade. The trading plan to set out the value of securities, what is the value of securities, or the number of shares I am going to deal with. That means I can say I am going to buy 1 crore rupees worth of shares, or I am going to sell 1 crore worth of shares. The price may be anything at that point of time, whatever it is prevailing, that many number of shares I am going to buy. Or alternately, I can say that, look, I am going to sell 1,000 shares, or I am going to buy 1,000 shares. Either of the ones I can give it. Specific dates, specific time intervals are to be set out in the plan. That means what are the dates, how much is the number of shares, or how much is the value. That is to be clearly given in the plan. Trading plan is required to be disclosed to stock exchanges prior to its execution. Trading plans can be executed, as I told you, only after cooling period of 6 months. And once the plan is publicly disseminated, it cannot be altered or deviated or withdrawn. That is a very important thing, because once such an important person who is holding a key position, once he submits his trading plan, that means people who are having access to that, who are having a knowledge of that, they might be also making their own plans. And tomorrow you cannot go and alter that plan. Tomorrow you cannot go and deviate from that plan, or you cannot withdraw that plan. The compliance officer should review the trading plan, and he is the person who has to approve that. So here a great amount of responsibility is entrusted upon the compliance officer. So he should know that how the trading plan is to be submitted, whether it has been submitted, the information need to be given is given or not given. All those things he has to review that. And he has to also take an undertaking from that person who is submitting that trading plan, that at the point of time when he is submitting the trading plan or the future, some information is going to become generated. He has to take an undertaking to that extent. That means the person who is submitting the trading plan is not having any kind of unpublished price sensitive information. At the point of the trade, what he is going to execute is going to be with him. Such concerned person shall also undertake that he would ensure that UPSI in his possession would become public before he commences his trades. That means when he is submitting the trading plan, if that particular person is having some unpublished price sensitive, whatever it is there, as I told you, these are the people who are submitting the trading plan. They are going to have the unpublished price sensitive information with them definitely, because they are the people who are having in perpetuity that information. So it is not like that he is not having that information. Whatever he is having it, by the time he executes his trades, it will be publicly disseminated. That means that information will be, in general, it will be available. However, for whatever the reasons it is, if that information is not publicly available, then despite the fact you have submitted a trading plan, you cannot still execute your trades on that. So the compliance officer's responsibility is to notify the trading plan submitted, which he has approved it to the stock exchanges. What are the restrictions on the trading plans? As I told you, there should be a cooling period of 6 months once approved before the execution of the first trade. It is so considered that such period is to be reasonably long for UPSI to become generally available. If it is not generally available, you cannot execute the trade. There is no relaxation from the trading restrictions around the declaration of financial results. Despite the fact you have submitted the trading plan, but you are around the financial results declaration time, that relaxation may not be there. According to Regulation 5.4, once approved the trading plan, it shall be irrevocable. This is what I told. And the insider shall mandatorily have to implement the plan. Come what may, there may be a crash in the stock market. He is supposed to sell the shares if he has submitted it. He is supposed to buy the shares, he has submitted the trading plan. That means he cannot deviate, he cannot alter, he cannot withdraw the plan. He is supposed to implement the plan. Such execution shall be without any deviation execution of trade outside the scope of the trading plans. Unpublished price sensitive information at the time of submission of the trading plan, if it continues remains to UPSI, then the trading plan cannot be executed. This is what I told you. The information what was available with him, actually it is presumed that the next, after the 6 months, by the time it will become generally available, if it doesn't happen, he cannot execute. Though trading plan is submitted and approved, the trades shall not be executed on a new UPSI. Suppose you have submitted a trading plan. By the time you are executing the trade, if some other published information which is there, that is going to have a market impact. Again, the same thing, you cannot execute that. So in view of these restrictions, in view of these kind of constraints, overall what happened is that trading plans remained unpopular. Thanks very much for your patient listening, and we will discuss it further in the question answer sessions. Thanks very much.
Yeah, thank you, Sudhakar sir. And certainly with this guidance note and with your address, we company secretary, we compliance officer will feel some relief, sir. But still, sir, compliance of other laws like this type of अपने को harass करता है, sir. What are the other laws? Okay, sir. Now I would like to invite Narayan sir, architect of this guidance note, Mahaguru of this guidance note. Please, sir. Narayan sir, over to you.
You are able to see the presentation?
Yes, sir. Yes, sir. Please.
Let me see how I can minimize this. This will come in the middle of. Okay.
Yes, sir.
So, friends, thank you. First of all, Sandeep and Pritesh for an excellent presentation. Sudhakar, thanks a lot for those kind words you have given for Makarand and me. But just wanted to place on record before we start the insider trading It was a humongous exercise and everybody who has pitched in. Our humble gratitude to all of them. I recollect the number of weekends, me, Sudhakar, we had Ranganathan, we had Kalidas. We used to assemble in Makaran Joshi's office on every weekend and deliberate from morning to night on various aspects, including questions which are received by compliance officers, interpretation issues, and amount of hard work being done by Makaran Joshi and his team is commendable. Specific thanks to even Deepti Joshi, I hope I've got the name right, who was part of Makaran's team and who has also worked tremendously on this guidance. I will also place on record gratitude for the hospitality given by Makaran and Deepti to us. And when they used to see that if we have worked hard, we used to get a thali from Tarachan Bhagat, which is quite a famous outlet. And that used to be a motivation for us to do our homework with much more extra zeal. So all people who have really contributed, dedication to you. And as Sudhakar said, we have merely a representative of all those people. And with that, let me start. What is insider trading? Pritesh, Sudhakar, both have alluded very nicely. And I don't want to get into it, but broadly, if you have unpublished price sensitive information, if you utilize it to your advantage and to the disadvantage of the market at large, it is insider trading. Before I get into specifics, I wanted to first make a mention of what are the new things happening in this field of insider trading. What are the new things which is happening? Probably 1 minute. How do I now it's minimized. I hope there is nothing obstructing the presentation screen.
Correct? Perfect, Narayan. Perfect.
Thank you so much. So what are the new things which are happening? And 2 or 3 things can really comes to my mind is the use of data analytics, AI, and delta analysis by SEBI. And what is delta analysis, friends? Delta analysis is a powerful metric used by SEBI where you net out all camouflage and complexity. Because when SEBI goes for information digging, you will get a huge dump of information. That information may be in a very unstructured manner. So delta analysis used by SEBI nets out the camouflage and complexity. It gives a simple measure how much approximate profit the insider stands to make if his directional view based on the UPSI turns out to be right, and how much loss he will stand to make if his directional view turns out to be wrong. So that's delta analysis for you. The second is use of AI and data analytics by regulators. If I have to give you a small example of saying you are in an analyst meet and there is a question raised by an analyst or a media person, mere raising of eyebrow by the concerned person, it could be a chairperson, MD, any member of the board, gives a different interpretation to an AI. And it will be interpreted differently by the regulator. So why I'm telling this specifically? Because as you're aware, under the LODR, all audio or video recordings and transcripts of all the post-earnings quarterly calls, you can name it whatever, whether it is conducted physically, whether it is conducted through digital means, it is conducted by the listed entity, or sometimes it is even conducted by any other entity. Every of such things, the video, audio and video recordings are required to be disclosed, uploaded in your website as well as in the stock exchange website. In fact, whenever there is an analyst, research or personal's meeting, and even if there is one-on-one, but what is it with the compliance officer needs to do to ensure that he gives complete guidance to the CIRO, to the IR guy, to say that no UPSI can be shared. Because if any UPSI is shared in such meetings, it will tantamount to selective disclosure and it will create information asymmetry affecting the market integrity, resulting in non-compliance with whatever within the framework. So in order to avoid such information asymmetry, what SEBI has requested to ensure that please follow regulations, only public information to be provided to all the analysts and media. You will have to have a recording of the analyst quarterly calls. The recording will have to be put up, and you have to actually guide your top management how to handle unanticipated questions. Because your top management, you will have two sides of the brains. On one side, you will have public information. On the other side, you will have unpublished price sensitive information. Even if you're provoked, how do you tell them to exercise restraint and never give up anything, even inadvertently? And of course, as I said, simultaneous release of information is a must. Let me give you another example of the way what we mentioned about data analytics. And here is a case of, suppose you are going through an analyst meet and there is an innocuous or an unanticipated question by an analyst or a media. And just imagine the two members of the board. It could be two members of the board. It could be a chairman and MD looking at each other with probably a sly smile. Or if they look amused with that question, this is interpreted by AI in a different way. So next time around, post an analyst call. If you get a notice from the regulator and you would be wondering, what have my bosses done at that analyst meet? Please note, it is AI at play. Okay. The next, which I wanted to make a mention, is about 2 or 3 Supreme Court judgments I wanted to just elaborate over here. And one which is pertaining to the connected person. As you're aware, who's an insider? An insider is any person who's a connected person or in possession of or having access to UPSI. So what is a connected person? Pritesh alluded in his part of the presentation also. Any person, he could be director, employee, professional, business, temporary, permanent, direct, indirect. It could be contractual, fiduciary, or employment relationship. So long as he holds a positions involving whatever relationship I mentioned, which allows access to UPSI or is reasonably expected to have access to UPSI, that person will be called a connected person. And what is the key thing why I'm making a mention before we shift to the Supreme Court judgment, which we talked about 2 major orders coming from Supreme Court. I wanted to first give you a background. One, as you're aware, connected person. In case of connected person, onus of establishing that they were not in possession of UPSI shall be on such connected person. And if you are not a connected person, or if it comes, the onus shifts to the regulator. Because there are 2 stages, friends. First, the onus of showing that a certain person who was in possession of or had UPSI at the time of trading would be on the base or would be on the person leveling the charge. What is the second stage? Once SEBI fulfills this onus, then the person who has traded whilst in possession of or having access to UPSI is then given a fair chance by SEBI to demonstrate that he was not in such position, or that he has not traded, or he could not access UPSI, or is trading whenever he was in possession of UPSI was squarely coming under the exonerating circumstances. What are those? Is given in Regulation 4.1.1-4, where insider can prove his innocence by demonstrating the circumstances, including matters mentioned therein. So in the 2 orders which we are going to say, one, they are broadly making a mention about connected person and what could be probably the decision given by the Supreme Court. Let's see. The first case, and thanks Rakesh for sending up this case in our group. Late evening, it motivated me to just prepare the slide quickly and to say how we could talk about the same. This case, mind you, is already there as part of the guidance note. Of course, The Supreme Court judgment which has come over yesterday has not come in, but this case is clearly covered even in our guidance note. So here is a case, some relatives like son's wife, cousin's wife, who are not covered under the definition of immediate relative, did trade in the securities of PCJ during the UPSI period. They all shared a common residential address due to joint family of extended relatives, which you can see in the slide. And chairman's son wife had further authorized her husband and her husband's cousin, who was also the son of the MD, to trade on her behalf through different accounts. So let us just try to decipher or peel the onion in respect of this case. Here's a case of three people, three brothers. One is a chairman, MD, and the third one was the ex-vice chairman. What was the UPSI? Let us see. In this case, the UPSI was buyback of shares. On 25th April, preliminary discussion started on buyback, and the moment discussion start, your UPSI period starts, you will have to close the window gets closed. On 10th April, the company intimates to the stock exchange about approval of the buyback. So this is UPSI period 1. Post intimation, as you're aware, one of the things is you have to take from your lead banker, you have to take approval. On 7th July, SBI, who's a lead banker, gives a refusal by way of an NOC. Between 7th and 13th, the CFO and other people try to convince the bank for getting the approval, but they do not succeed. On 13th July, finally, there is an SC intimation given by the company for withdrawal of the buyback. So there are two UPSI stages, friends. One is UPSI 1, one is UPSI 2. UPSI 1 stage was when you were just about to announce your buyback. And when the buyback was announced, the share price went 10% up. And on 13th July, when the buyback was withdrawn, the share price further went down by around 20%. So who are the people traded? Both SG, SIG, husband and wife, and on the extreme right, if you see AG and NG, both and their one company QDPL, all three have traded during the second UPSI period. That is between 7th July and 13th July, when the cancellation of the proposed buyback was in the offing. It was at that time that these people traded. So what is the allegation made by the regulator? The allegation made by the regulator was that the MD of this company did knew about this proposed buyback as well as cancellation of buyback. Is there any proof? SEBI does not have wiretapping. SEBI does not have any other facility. So what SEBI says, using the doctrine of preponderance of probabilities, which we call, and saying that you all are all in the same address, there is a relationship between all the people you have, I am going to assume that it is the MD who has transferred this information to these two sections of people, and basis this information, these people have traded, and hence it is insider trading. So they use preponderance of probability to just make a mention about this. What is the Supreme Court today, yesterday's order which came out, merely making a mention, is that in this particular case, the whole time member had actually come to a conclusion that these people are probably not connected person. And what did we see just 2 minutes back, which I said, if you are not a connected person, then the onus on establishing shifts to the regulator. And if you are a connected person, then the onus shifts on you. The crux of the judgment which Supreme Court is trying to say, if you are not neither a connected person nor an immediate relative, okay, then when you are making any allegation of communication of UPSI, it has to be proved by materials like, is there a letter, email, witnesses. Allegation cannot be basis of alleged proximity because the parties are neither CP nor IR. And so SEBI allowed appeals filed settling the order of SAT, which had upheld the order of the whole time member, penalizing the people involved in this particular trading. So another important point, but Yesterday, I saw a lot of WhatsApp group, even including today, which says that SEBI has lost its power to exercise preponderance of probability. I don't think any of thing is right. As you're aware, in much other cases, which I'm also going to allude to right now, I'm going to also make a mention to that. Said that is not it. Every case will be specific. This is a case-specific things, and I'm just going to request professionals not to overgeneralize basis one judgment. Let's move to the second judgment. The second judgment, actually, Pritesh had already made a brief mention as to whether non-executive and independent liable directors can be liable as insiders under the SEBI PIT regulations. Again, going back to the definition of connected person, if a person holds a position, I said, whichever type of position, temporary, permanent, direct, including frequent communication with officer, if the position allows access or is reasonably expected to have access to UPSI, you are a connected person. In this particular case, as you are aware, what was the arguments made out? Arguments made out for we are all non-executive directors. Executive directors, management have a greater access to UPSI. NEDs do not actively participate, as you're aware, in the day-to-day affairs of the company and have minimal access to UPSI. And what will be the source of UPSI for an NED or ID? Their access will be limited through the agenda and information placed before the board or the committee meeting. So any person is included within the ambit of connected person. The key, as I said, deciding factor is that does that position allows access to UPSI or is reasonably expected to have access to UPSI? And now let's see the nuance. How is the term reasonably expected to have access to UPSI is interpreted by Supreme Court in the judgment. Supreme Court says that the moment you are talking about the reasonably expected, it cannot merely be a ipse dixit, which they call. And what's an ipse dixit? There must be material to support reasonable access to UPSI. So probably what is the order coming out? That presumption of access to UPSI would need to be supported by evidence. There must be material evidence to show that such person reasonably has access to UPSI, and this must be applied as a test even to check if non-executive directors are insiders and whether they are liable under the PIT regulation. Therefore, NEDs being a connected person are presumed to be in possession of course, UPSI. However, this has to be supported by material evidence. Hence, as I said again, in civil law, there is going to be at any time preponderance of probability, which is going to be used by SEBI. As you're aware, in many of the FUTP cases, including Ajmera, Raki trading, Supreme Court has upheld highest standards of preponderance of probabilities. In fact, if you see the judgments, they've clearly said the charge of insider trading is one of the most serious charge in relation to the securities market. And having regard to the gravity of this wrong, they say higher must be the preponderance of probabilities in establishing the same. And most important, as you're aware, while if you make a differentiation between the laws, insider trading laws in India and US, while India has gone much beyond even US in insider trading regulation. It is, I will say, 3 to 4 notches above US. However, in the key difference in implementation is, in US, every crime of insider trading is criminal. And when you're making criminal charges, you cannot have preponderance probabilities, because these principles can be applied only to civil cases where the charge is to be established not beyond reasonable doubt, but on preponderance of probabilities. So as far as SEBI is concerned, as you're aware, they have never, I've never seen any SEBI till now, while they have powers, they have not gone criminally against anybody. They will always use civil law. They will penalize, they will restrict access to market. So broad guidance has been given even by both domestic and international courts that if you want to have a sustained insider trading conviction based on preponderance of probability and circumstantial evidence, you will have to consider many factors. Factors such as access to information, the relationship between the tipper and tippee, timing of contract between tipper and tippee, timing of the trades, pattern of the trades, whether there has been any attempt to conceal either the trades or the relationship between the tipper and tippee. So broadly, these are all material factors which will have to be taken into consideration by the regulator and the judiciary. Hence, I will only make a humble submission to our fellow colleagues. Do not generalize by merely getting a glimpse of the order in WhatsApp. I always remember Sudhakar jokingly saying that today you have, he uses a term called WhatsApp University, which I find it quite amusing. He always say people can even graduate through WhatsApp universities today. So hence, we would only request this order will also be, we will add the core group. We will also go through it thoroughly. And of course, when we are revising it, the guidance note, we will ensure that this is also taken care. Now I'll go to the second element of what are the key pain points of a compliance officer or a company secretary. And that first pain point, which I find where people probably go inadvertently to the wrong side, is closure of trading window. Let me first start with a case of closure of trading window. Here is Sun Pharma acquiring, that is actually Ranbaxy is being sold to Sun Pharma. Sun Pharma is acquiring Ranbaxy. In this particular case, this is the UPSI acquisition. Okay, SEBI goes through records and emails of right from last 2 to 3 years. When did Sun Pharma first approach Daiichi? Daiichi was the promoter. SEBI examined emails sent by Sun Pharma's advisors to Daiichi. Several emails were exchanged between advisors of Sun Pharma and Daiichi forwarding the proposal to their advisors. But an important element came from the order. And what was an important element? They said that the major aspect in any M&A deal is agreement of the principal shareholder and management of Ranbaxy. No transaction, whatever could have taken place without Daiichi's acceptance, correct? So you can keep asking for the bride's hand, but till the father of the bride, I'm talking about, says yes, we say generally it's not a done deal, correct? So while SEBI is going through a slew of emails, they find that on one of the particular days, I thought 31st January, there was a presentation made by advisors to the board, okay? And a presentation and appointment of financial advisors, Daiichi sent out a mail saying that we are okay with the deal and asked for timelines for the closure of the deals. So from the moment there is a broad okay from the parent of the bride, in this case Daiichi, SEBI says it can be inferred that on Feb 14, Daiichi has agreed to Sun Pharma's proposal to acquire Ranbaxy, and hence on that day, information becomes price sensitive. A beautiful judgment if compliance officer wants to just know the nuances of closing trading window. At what stage do you close window? Because they say when this email of the parent of the bride, with the promoter of Ranbaxy asking for timelines came, you have asked for the hand of the bride, the father and the parent has said yes. This is the stage when UPSI, unpublished information, becomes UPSI. Unpublished information becomes unpublished price sensitive information. And at least from that day, that is February 14, till the day you have disclosed this to the stock exchange, that is till April 7, thou shall not trade. You should have had a complete ban. What happened, unfortunately, in this particular case, the CEO of the subsidiary did trade, and the contention by the CEO was, since the board meeting was on April, I think 7th or something, it was only during that day or 1 week before we got the agenda, and the earlier trades should not be and ought not be considered. However, the regulator said that we have clearly established at when and at what stage information became unpublished price sensitive information. This is the email by the parent of that company accepting. And once you are a member of the project team, and when you know the opposite party has already accepted, ask for timelines after that day. To say that it is still not UPSI, will wait for the agenda, would not be right. And hence the say person was prosecuted. Of course, it came for a settlement. Hence, if you say there will be multiple times compliance officers will have to close the window. One is the periodic trading window, where there is no major discretion available because it's from the first of the quarter till 48 hours plus, correct? However, when you have events like mergers, acquisitions, takeovers, when you're doing, you will have to probably see at what stage are you going to close the window. As you're aware, there are two doctrines for closure of window which is available. One is which we call in US. In US, they have a concept called half-pregnant theory. It's an aggressive Western view where they say the transaction, what do you mean by half-pregnant theory? Is the transaction becomes a UPSI where it is impossible to abort the transaction without causing harm to the mother or child. So if without causing harm to either of the parties, if you are going to say, I cannot abort, at that stage, they say it becomes non-public or unpublic price sensitive information is born or germinated on that day. In India, the way we talked about this particular case, we take a conservative stage. In companies, we will say we'll have 3 stages. Flirtation stage, which we call window shopping, is allowed. You can go to today itself, M&A department can go and window shop, do flirting with every company in the world. However, when as a team you decide that now you are serious, you first go for in a matter of say till flirting, till window shopping, it is still not UPSI stage. But the moment you say I'm serious in a relationship, I want to get engaged, you will go to your parents and seek blessings. At that time, similar is the case with the company. If you see, it has become important that I know now there is concreteness is coming. I will approach my board or committee equivalent to a bride. What I'm saying, the board and committee, the company secretary will have to say, if it has become right for it to come to the board, I will now have to close the trading window for you. And entire project team should be closed. And when will it close for the board members? When the agenda item containing such proposal is sent, at that stage, you will close the trading window even for the board or committee members. Second case coming out, again, huge lessons for compliance officer. And by the way, just wanted to make a clear mention, intention of just taking, they are all in public domain, is to just get a clue of to say where compliance officer probably may go wrong and how do you learn from some mistakes or some errors and how do you learn from judgment. The intention will never be to be critical about any company which is being mentioned today. Here is a case of Pfizer and Aurobindo. They have a licensing and supply agreement between them. For their first agreement, second agreement, multiple agreements are signed. What is the allegation made by the regulator? He says non-closure of trading window while you have this license and supplying agreement. Delay in disclosure because you had series of agreements. However, the disclosure was made after a period of say 70, 80, 90 days. Okay. And there were creeping acquisition by promoters while this UPSI was going. So friends, mind you, creeping acquisition is under SAST, takeover regulations, while a promoter can creep up to 5%. Please do not mix it up for insider trading by say, I can creep or do a creeping acquisition even when there is UPSI. That is not allowed, correct? The more important thing coming out of this particular case is if a company decides not to close trading window, claiming it's not material. In this case, they say it's ordinary course of business. We have license and supply agreement across for multiple companies. We don't consider it as non-routine. If you once take that stand, then please ensure that your media communication is also to be in sync with this. Else, the regulator will be scanning every word. Because if the agreement was not OCD, was an ordinary course of business, if it is not material, and they said that there was no need for closure of trading window, and they said that the disclosure was a consistency with the press release was made. But when the regulator saw the press release being made, and which was disclosed also to the stock exchange, the press release did not give the regulator an impression that it was business as usual. The press release went on to say that it's an extension of the medicines in multiple countries, okay, and it will dramatically change the portfolio of the products we have. And they went to such an extent to say that the non-exclusive market for this particular product is going to grow probably much more than 10x. If that is the type of capacity planning you are having, that is a type of increase to your top line, bottom line it's going to make, then you no longer can say that it is business as usual, it's ordinary course of business. And then if you do not close the trading window, even you as a compliance officer is going to be prosecuted. So hence, please ensure your stock exchange intimation, media reports, corporate announcements, press release, all are talking the same language. As you're aware, even in other one or two cases, SEBI has said that once you have disclosed under clause 30 and saying that it is price sensitive, you will have to then prove to me why was it not price sensitive for the purpose of closure of trading window. But it would ask you for that rebuttal, and you should always be ready. And I thought this is always probably a tricky area where compliance officers are doing. And I will just wanted to touch this additional case law where there was trading on the basis of UPSI, and this case law gives to a great extent minute clarity to the compliance officer and company secretary when will closure of trading happen. And this is a recent case law, and here is a case where there is a collaboration between two companies on next generation products. Company is saying it UPSI has not been generated on a particular date, and because there is no trading window closure, one of the designated person traded. The allegation was he did make a false declaration that he was not in possession of the UPSI, but the company on the other hand said that we didn't feel that on that day UPSI has been germinated. Okay, so there have been series of events which took place in this particular company, whether in terms of discussion, due diligence, negotiations taking place. But in one of the points while coming, they saw that the two parties have exchanged press release and Q&A. Then the regulator says that if it has come to such an extent that the PR teams of two companies are talking, I would say it is a done deal. That was one. The second thing which is coming out very nicely in this judgment is, and we have alluded to this even in our guidance note, all I'm just going to tell the amount of deliberation which happens at the regulator and how we also try to interpret each one and try to give it to you on a platter. In this particular case, SEBI has beautifully dissected it, and they call it the three-bucket theory. And what is the three-bucket theory? They say there is a distinction between three buckets. What is the first bucket? They say the first bucket is when parties have just opened discussions. The second is UPSI period, and the third is, of course, final signing. And the question is, how do you decide in which bucket you are falling in either of the three buckets? Okay. So this judgment is beautifully deciphering this matter of saying, when do you fall in the first bucket? They say you will fall in the first bucket when discussions are exploratory in nature, information generated at this stage is very imprecise, it does without a reasonable probability of the transaction going through and without any specific details. Then the question is, when do I know? I go to the second bucket, that is the UPSI period. Mind you, the second bucket is the UPSI period. The order today to a great extent gives guidance. Second bucket is where there is high degree of crystallization. when you proceed towards greater degree of crystallization, where there is reasonable probability of the transaction going through. And at every stage in second bucket, it inches towards a higher degree of correctness. And this is done in a structured way by resolving issues. Okay? Because what they say, during the UPSI period, with each passing day, unresolved issues are being ironed out. Outcome of the transaction moves towards higher and higher degree of concreteness. Discussions are centered around resolution of specific issues. And most important point they have pointed out, which is a huge, I think, takeaway for we as compliance officer, they say, merely because you say there is no 100% certainty on what will be the outcome, there will be still room for parties to change, modify decision till the time the decision has been probably publicly announced. Okay. And in this particular case, they say if merely because there are, say, 30, 40 items which are to be ticked box, it can't be said that nothing is happening between parties. I think this is no indication for you as a compliance officer to tell me that I'm still in the first bucket. It's merely a discussion stage, because the negotiations, which represents series of steps taken by respective teams working on the deal and senior management of either side to resolve outstanding issues. And they've gone through many multiple emails. Some emails says some thoughts to resolve stalemate. They say that proof is that while I'm saying deal is not finalized, but this shows that negotiations are passing through concreteness and indeed moving towards finality. Okay, so certainty of information can only be measured in terms of probability, degree of crystallization. And they said that on one of the days when you have exchanged press release and Q&A, and I say involvement of PR teams, I will presume that you're going to a PR team only when in principle you have agreed between the two parties. Many emails are being say, in fact, the tone and tenure of the emails were checked, because some emails said they speak with you soon as we work to close our collaboration agreement. And every tone and tenor has been seen. So again, in an M&A, believe me, every emails which you exchange will be open to dissection, will be open to investigation, and you will have to ensure UPSI period does not merely mean that there is no possibility of the failure of deal. UPSI start period cannot be and ought not be when the deal is 100% to go through. That is what we call no room for failure. So there are multiple, factors that determine trading window closure. As I said, nature of the transaction, how it progresses, outcome of various stages of negotiation, increasing possibility of transaction going through, and we have to consider all before doing a window closure. And post window, once you close the window, then at least you have made and you have at least to document what are the basis on which you will have to do this particular window closure. And the more important thing in this particular case, and what is coming out in the last 3 or 4 cases, the general impression what we have, if it is a positive UPSI, would you buy or sell? Correct? So in this particular case, they say that the noticee has sold and not purchased shares while in possession of UPSI. That is, prior to the announcement of the collaboration, can an insider be guilty of insider trading if an opposite transaction is done? This is the second thing coming out for compliance officer, for you to say that if I have a positive news and I press the sell button, which is there in your screen, can I still be guilty of insider trading? Similarly, if there is a negative news and I press the buy button, would I still be prosecuted for insider trading? As you said, can any person selling shares prior to a positive news be charged for insider trading? And there were multiple claims being made that insider has not gained any undue benefit, shares was sold for making payment of certain property opposite to common law jurisprudence, insider has not taken advantage. Shouldn't the rationale be to punish a wrong rather than getting into this? There were even reference given to the high-level committee chaired by Justice Sodhi, where he has said that an insider trade, if it is contrary to the nature of UPSI, such need not be a wrongful act. However, after hearing every of this argument, SEBI actually, this again is a very nice judgment. They have referred to this particular section in 4.1, which basically is a charging section which Sudhakar alluded to in his session, which says that no insider shall trade in securities that are listed or proposed to be listed when in possession of UPSI. And the key point over here is in the explanation. And what does the explanation to the section say? When a person who has traded in securities has been in possession of UPSI, his trades would be presumed to have been motivated by the knowledge and awareness of such information in his possession. I again repeat what they're saying. When a person who has traded in securities has been in possession of UPSI, his trades would be presumed to have been motivated by the knowledge and awareness of such information. So what is the impact of this? While you've heard arguments from both sides, as per UPSI definition, effect of UPSI on securities can be negative or positive. Merely because the notice claims that if he is in possession of UPSI, he would have sold after price increased. That has been found incorrect because they say possession of UPSI does not presuppose upward movement of the script. That is why what I told at the beginning, we talked about data analytics. We talked about delta analysis. That is a place which I wanted to tell you that this data analysis clearly removes the camouflage. And if they say that if everything would have, whatever you had planned, what is the profit you would have made or what is the loss you would have made, it has got nothing to do with the type of trade which you do. And whether it was many cases which they had referred to, whether it was Chandrakala versus SEBI in SAT and other cases which they had also referred to. However, this explanation to this section was quoted by SEBI, and we need to say that how, like both Sudhakar and Pritesh was mentioning this even in their session, there may be case laws, but with every case laws, the law emerges and we get a new interpretation. And we need to be very careful about this when we are doing window closure, when we are getting into multiple things. How are we on time? If we are closing to the time, I will stop here. Otherwise, I can just continue on how do you get into diversification and closure of trading window. But who, Rakesh, you have taken over or Sandeep?
Yes, sir.
So Rakesh, I can just spend more 5 minutes on this because it's a diversification matter. But if we are closer to the time, what's the time right now?
Sir, it's 5:45.
Oh, so then I will stop. Then because we will have to give some time for FAQ also.
I think Narayan, in all fairness, you know that because this is also a very important point. What you are going to the next slide, you may take up another 5 to 8 minutes, and quickly you can wrap up. Okay, that will be helpful to everyone.
No, but it would take, because this particular case law, Sudhakar, is going to take a lot of time, is what I wanted to say, because it will. This is a diversification program, and by the time it takes more than 10 to 11 minutes, we'll be very close. And then if you have to not take,
try to give a bird's eye view, Narayan. That is what my submission to you. Try to give a bird's eye view.
What I will do is we can always what we can do. Let's do the FAQ if required. I don't know what is the number of questions you have received, Rakesh. Depending on that, and then at the late, if you have time, we can always.
Okay.
But
great.
Thanks a lot, Sudhakar, Pritesh, for setting the background. And I thought we would just try to peel the onion a little bit. Like Sudhakar said, every day when we ourselves read, when we used to read, when we were doing this guidance note, we used to get a different meaning. And thanks to you, Rakesh, your late night, you had sent it in our WhatsApp group. This particular Supreme Court judgment really came handy. And I thought overnight, virtually, I had to prepare the slides so that the whole thing of saying is how guidance note. People, what I'm saying, even if you have the best of guidance note, but if it is going to rust in a library, it's of no value add. So this is what Sudhakar, Makaran, et al. Have been telling, that unless and until our company secretary professionals see value in it, how will it help me? So we are trying, so the whole purpose of this SS week is how do you get from probably getting a film filmed in Cannes or in one of those critically acclaimed to a Rohit Shetty mode, which we said, So that's whole purpose of this guidance, and see how people perceive value add, and we not merely because Sudhakar or Narayan is telling it is value add, is the company secretary fraternity really treating as value add. Over to you, Rakesh, for the Q&A. Thank you.
Thank you, Narayan sir, for such a very detailed presentation and covering all the aspects of the PIT regulation, not only the PIT regulation, but what are the various other factors like germination of UPSI, how it will be considered, and how the latest judgments of SEBI to, compiling into various buckets to determine at what point of time it will be created. So it's really a knowledgeable session. And now we quickly move ahead to the question and we have received many live questions, out of which we have shortlisted few, which we have seen are really important to address. The first,
Rakesh, the ratio of the questions is 2 questions to Narayan and 1 question each to us.
Please. He is being true. He has been kind and generous. The amount of, we know, Sudhakar, the amount of hard work you put in, and I don't think this SS week would be possible without the push which you have been and your passion. I don't think none of us can compare it with your passion and which you have for the institute and the giveaways which you give. So thank you.
Rakesh,
please go ahead, Rakesh.
So, sir, I am putting first question to Sudhakar, sir, and whether it is mandatory to appoint company secretary as compliance officer for the purpose of PIT regulation. This is one part. And the second part is, can a company have multiple compliance officers, like for the purpose of compliance of LODR, for the purpose of PIT regulations, to ease the burden of compliance on one person? So what is your take on this, sir?
See, as far as your PIT regulations are concerned, company secretary need not be the compliance officer. As in fact, Pritesh has mentioned about the definition, whatever it is given, the compliance officer should be a senior person who should be reporting to the board directly. So that is what the requirement. And then, of course, he should be financially literate. He should understand the PIT regulations thoroughly, and all the other requisites are there. As far as LODR is concerned, listing regulations are concerned, the prerequisite for that is the compliance officer should be a qualified company secretary. So there also the company secretary of the company need not be the compliance officer. So I always used to say, in fact, when the listing regulations, I used to go for this roadshows like this. So that point of time, I used to say it is in the interest of the company secretary to appoint someone else as the company secretary for the purpose of listing regulations to share the burden. And as far as the PIT regulations are concerned, it is advisable, considering the sensitivity, considering the nature of the regulations and all, in the interest of the company, it should be the company secretary of the companies, should be the compliance officer, though legally it is not so required.
Thank you, sir. So the next question is for Dr. Pritesh Majumdar. Sir, whether insider trading is really a risky subject for any company secretary, and what precautions would you suggest to be taken by a company secretary to avoid any liability out of it?
Yeah, so it's a very interesting question, and we always grapple around this every time. So, first of all, there should company secretary, presuming that he is a compliance officer for the purpose of PIT regulation, ideally the defenses which would come up in case of any regulatory inquiry or investigation is that whether the defense is available, whether there is a proper comprehensive policy which is required as per the regulation is in place or not, whether there is a code of conduct built up, and whether a proper training and awareness of the code of conduct and the policy has been given to designated persons. Because one thing is very important, that monitoring the trade of designated person is a responsibility of the designated of the compliance officer. So he has to ensure that proper training and awareness is required, and set up a in-house vigilance function wherein the consolidated account statements could be procured from the designated officers, and review the trades which have been done. And a lot of technological help also can be taken to ensure that there are no slippages there. So I think having this infrastructure built in, a company secretary definitely would be able to largely adhere to the PIT regulation.
Yeah, thank you, sir. My next question is to Narayan, sir. Sir, what compliances a compliance officer should adhere in case a designated person resign, and especially when such designated person has traded in the securities of the company just 2 months before his resignation?
2 months before or 2 months after?
2 months before his resignation, he has taken the permission for that trade, and he has executed that trade by obtaining the permission from the compliance officer before 2 months of his resignation. After that, he resigned.
So, but has he traded during an UPSI period?
No, that is not mentioned actually in the query. It is just mentioned that he had the pre-clearance.
Okay, I'll broadly try to cover. As you're aware, the compliance officer today is duty bound to monitor trading by designated persons. Okay, so when a person resigns, what happens? Upon resignation of a designated person, he will no longer be a designated person, but he will move from the bucket of designated person to a connected person. And he will be a connected person for a period of 6 months. This is put as part of the definition itself of connected person. The duty of monitoring trades is only vis-a-vis the compliance officer, or the company secretary is only vis-a-vis designated person and not connected person. You are aware of guidance which has been given by SEBI that the company should maintain updated address and contact details of all designated person for a period of 1 year after resignation of service. Such data, they say, should be preserved by the company for a period of, say, 5 years. And that they have even gone to extend to say that we have given this even on our guidance note that the term resignation would also include within its ambit retirement. And why is this 6 months probably given is, you say that once you resign, it is not that the moment you resign, the next day UPSI vanishes, correct? Broadly, SEBI say that it will take around 6 odd months for all the UPSI which you know about the company to go into public domain. So till 6 months, till the time you are a designated person, till your last date, you will be a designated person. The compliance officer will monitor your trade. He will be monitoring through your PAN numbers, either directly or through an RNT agent, as we know. But after that, there is no requirement, quote unquote, to do that. But on the connected person himself, that is employee, after resigning, he cannot for a period of 6 months do anything which is violative of the regulations and code, because he will still be a connected person. And as I've said in the earlier cases, it will be a huge onus for him to say, why did he do anything? And on the second question, he traded 2 months before. And probably you are saying that he has taken pre-clearance. If it is not during a window closure period or not during an UPSI period, during his tenure, during his resignation period, there is no harm selling of shares or doing a trade, provided you are not in possession of UPSI or the trading window has not been closed on you. But on a very safer side, we say if you are a designated person, please stay away from the stock of the company. Do not get into, because you never know when you can get caught into this trap.
Yeah. Thank you, sir. Sir,
Rakesh, only one small thing I want to add further what Narayan says is that when he is talking about the trading, not necessarily you have to do the trading directly. If you are having a PMS scheme, port management folio scheme is the PMS scheme is there, and your PMS manager is doing something in your company's securities, and you will be held responsible for that. So if you are having a PMS, you have to clearly give a direction to your PMS manager not to deal with the securities of your company, and you have to keep a track of that also. This is for the benefit of the participant. I thought I will add this.
No, but very important point, Sudhakar, you've raised, because what you have to understand, that's why I said stay away from trade, because I'm saying we get multiple cases like this where people who may not know the nuances inadvertently get caught. Even in PMS case, even if you give a negative list, during COVID, we saw an inadvertent trade happening. And when we asked how's that inverted trade happened, then the answer was, this were systems when we were in office. Because we were working from remote, probably the systems didn't get updated to the relationship manager, and that information didn't get into it, and the trade happened during trading window. The same thing happens with SIP. The same thing happens when you're pledging shares. As you're aware today, even for the broking account, you require your shares will be pledged. And you don't know when you are giving collateral at what time the market price is down, and if they fear that your security, the collateral is not matching the amount which they have given as loan, they are going to dump the stock, and that dumping can happen even during a window closure, and you can still get caught. So I thought very important point raised for PMS, SIP, pledge. Thank you, Sudhakar, for it.
Yeah, and sir, just to add that there is an informal guidance also,
yes,
which clearly mentioned that even if you are given to a discretionary PMS,
absolutely,
still you are within the ambit of PIT.
Correct, absolutely, bang on.
Yeah, thank you, sir. Thanks for sharing your views on this. We have next query for Sudhakar, sir. Sir, is there any format prescribed for maintaining the structured digital database, or the companies are free to maintain it in any format? What is your...
No, there is no format as such which is prescribed for the maintenance of the data in the digital structured digital database. But what the information to be given there is mentioned in the regulations. Based on that, a format can be devised by the company itself. But please ensure one thing, that you should capture wherever the information is shared, the way I have mentioned it, that should be captured properly, and it is a responsibility of the company secretary of the company. And he cannot say that, look, I have not been given this information, so I could not maintain that. That is not an excuse at all.
Thank you, sir. Sir, my next question is to Dr. Pritesh Majumdar. Sir, what are the consequences of trading in shares by designated employee of the company during closure of trading window? Or what if such trading is done at a loss, that he has not earned any profit out of that transaction? So what is your views on that?
So at the outset, we know that the objective of SEBI prohibition of insider trading regulation, it says that insider trading is prohibited, but trading by insider is regulated. So if there's a designated person and during the up-C period, a trading closure period, if he has traded, then it's a breach. And definitely then the adjudication machinery would then move on it. And it doesn't matter whether he has made any profit or loss, because he has traded and the act has been committed.
Thank you, sir. Sir, my next question is for Narayan, sir. Sir, whether an intrastate transfer of shares amongst promoter for a consideration or gift is allowed during the closure of trading window?
So, as you are aware, when you are doing, when there is a trading window, there is a complete ban on trading by promoters or anything. The only exemption or exception which has been given is in Regulation 4.1 to 4. I think Sudhakar had also covered as part of his presentation, where you have 3 or 4 cases where they said that what is the basis on which the designated person, promoter being part of the designated person, can prove his innocence during that time. And one of the innocence clause which comes under 4.1.1 to 4, which we say, is this particular clause, that if the transaction, if it is an off-market interstate transaction between insiders, between say two people having the same UPSI, you could probably say that it is not detrimental. The second, you say even if it is a transaction through a block deal, Sudhakar had also made a mention, that could be one of the things which, but at the end of the day, what you have to understand, you are now shifting from 3 to 4. Because when does 4 come into play? 4 basically says no insiders shall trade in securities while in possession of UPSI, correct? That's a basic principle. When a person who has traded in securities whilst in possession of UPSI, as I said, his trades would be presumed to be motivated. And the rebutable will be, the onus will be on you to prove it to the other side. So while you have an exemption being given in 4.1.1 to 4, please understand you are then put into high degree of rebuttal of saying you have to prove your innocence by demonstrating circumstances which include 1 to 4. So my personal view would be during trading window closure, as far as possible, stay away even if it is an interstate, while still it is an option available under 4.1.1 to 4.
Yeah, thank you, sir. Sir, what will be the situation if the designated person is trading in the shares of the company after getting the approval of the compliance officer, or we can say that trading plan is already approved? Then what will be the situation if trading window is closed? Can the designated person trade in shares of the company?
Sudhakar, you would like to take, because you have taken trading plan, I thought your subject, but.
Yeah. See, that here, as I mentioned in my...
Because you had already mentioned this as part of a presentation.
Yeah, exactly.
This you had already covered, that's why.
I have already covered that. In fact, once you submit the trading plan, there is a cooling period of 6 months. It is there in the public domain. So that's why pre-clearance is not required. During the trading window, you can trade it. Rather, you are supposed to trade, because if you are given the dates on which you are going to trade, I mean, that you are buying or selling, whatever it is, you are supposed to do that on the particular dates. There is absolutely no prohibition for that. Even contra trade also is not applicable.
Sir, again, there is one relevant question on this only. Whether company secretary will be held liable if promoter do trading in securities of the company during trading window closure without any intimation to the company secretary about that trading.
First and foremost thing is the company secretary has to take all precautions when he is closing the trading window. The communication should be prompt enough, and wherever it is required, he need to what's called as sensitize the people about the window closure and what they are not supposed to do it, especially in case of senior officials, especially in case of promoters, directors and all. By merely sending a email, he should not keep quiet, according to me. He should sensitize the people about this particular thing. And second thing is, despite that, if somebody has done something wrong, the company secretary at least should be able to capture that when he is getting that benpost, that point of time something wrong has happened, and he should be able to initiate the process. When something wrong has happened, what is the process he has to initiate it? He should be able to do it. He should not keep quiet. He should not put that wrong under the carpet. He should brought it to the notice of the concerned audit committee or whatever it is. And whatever the requisite action is there, it is to be taken. And maybe he has to inform even the SEBI also about that. He should not keep quiet.
Yes, sir. In fact, sir, just to add, as per the regulations, the duty of the company secretary, who is the compliance officer, to promptly intimate to SEBI of any violation.
Yeah, that's what I said.
Yeah.
Yeah. And Sudhakar has mentioned, Rakesh, a very important point of even while you have to ensure that you have given all documentation of email of trading window closure to the promoter, to saying that the window is closed, UPSI is now come into place, please do not trade. The key point which Sudhakar today, second point which he has raised is that you also get the benpost. And as you're aware, this we have covered even as part of the guidance note. And here is a guidance note, here is a, what do you call, informal guidance, an outcome of the, I think it was at SAT, where there was an allegation in respect of our colleague Rajendra in ITC, because 7.2 stated that you are going to make disclosure within 2 trading days of receipt of the disclosure or from becoming aware of such information. So the question was, a compliance officer getting a BenPos, will he come within the purview of becoming aware of the information of transaction? And that was very nicely dissected in the ITC case. And finally, they made a mention that there are crucial details required for making disclosure under 7.2. BenPos is a limited information. And they finally said that while you can, there is no major thrust on the compliance officer to probably do a wild goose chase through the BenPos and disclose. I thought I'll just make this additional informal guidance which was given to ITC.
Yeah, thank you, sir. Thanks for sharing your views on this query. My next question is to Dr. Pritesh. Sir, is media speculation or prediction can be considered as UPSI? And what if somebody trade on the basis of such news before that actually become public or formal announcement is made by the company?
So I had covered this in my presentation as to what is generally available information, and I explained that what is generally available information is antithesis to what is a UPSI. So if the information what has been published on stock exchange or which is put up in a public domain without any discrimination becomes generally available information. And in the past, it has been decided that speculative reports in print or electronic media is not being considered as a published report. So any speculation, is not a information which is generally basically available information, and hence may not be seen accordingly.
So if you see, Rakesh, this has got to do, if you say, some history around what had happened. If you see the old time case, if we have to just dip in, and how the definition, actually this will be a great for our compliance officer, how the definition of UPSI has changed over a period of time, because there was once earlier, prior to the PIT regulations 2015, there was a concept of price sensitive information. Then you had unpublished price sensitive information. You are aware that even I remember the HLL and Group Bond case, where the contention taken by them was it was generally known in media reports. Thereafter, post that particular case, actually the regulator got an explanation to say speculative reports in the print or electronic media would not be considered as published information. That was regulations as of that time. And after a series of, I think, deliberations and at various committees, they finally came to this conclusion of saying that if an information is relating to the company or securities directly or indirectly, that is not generally available. So today, the key emphasis would be, is it generally available? Which upon not generally available, which upon becoming generally available is likely to materially affect the price. And mere media speculation, if it is not disputed by the company or not given by the company, merely media carrying a story, you cannot say that I thought it is already published information and hence I trade it.
Yeah, thanks, sir. Thanks for sharing in detail your views on this, and also the relevant judgment on this in the guidance note also. Sir, my next question is to Sudhakar sir regarding the trading plan which he has covered in his presentation. Sir, is it mandatory to execute the approved trading plan? What if somebody neither sold nor purchased any shares under the trading plan, citing various reasons for that? And if there is any penalty for not executing such trading plan?
Yeah, I see that. In fact, again, the same thing, this particular questions I have already answered that. Once you submit your trading plans, you cannot deviate it, you cannot alter it, you cannot withdraw it. because the trading plan has been disseminated in the public domain. Based on this trading plan, public would have got their own planning as far as their shares investment or trading is concerned. So that is the reason it is very clearly mentioned that once you submit the trading plan, you must implement that. Okay. Now, if you are not implemented that, what will happen? Obviously, you will be that whatever the penal provisions are there, they will get triggered. And you have to face the consequences for that.
Yeah, thank you, sir. So the next query is for Narayan, sir. That is UPSI has to be futuristic information only, or it can be a historical information which is not yet released in public domain?
So I'll give the information broadly, this context in context. What is the definition of UPSI, Rakesh, which we say any information pertaining to the company or its securities, which is not generally available, which upon becoming generally available will materially affect the price of the securities. So the key information is what is information and how is it getting into unpublished price sensitive information. So if I have to say broadly what the stand councils take, that if it is futuristic information, budgets, or futuristic saying this is my 5-year plan or some budgets, generally may not come within the purview of UPSI. It will have to be concrete information pertaining to the company or its securities. But if I have to give a twist to this, while you say budgets may not come within the purview of UPSI, but when the same thing comes towards a month end or a year end, or if I'm going to say I have given a budget last year for this year, that we consider not as suppose UPSI. But in 15th of March 2022, I am making again a change in that budget, a very close. So then you're saying you are moving from what you can say fiction to reality. And just 15 days or few days away from your closure of a financial year, then it is no longer futuristic budgets or scenario building. You are more talking basis the orders which you have in hand, basis much more information which you have, which public at large is not having. And that's exactly the crux of insider trading. That if you have UPSI and the others do not have, do not either communicate, do not procure, and do not trade.
Yeah, thank you, sir. Thanks for sharing your views. We have one next query which is related to UPSI only. And I place this query for the panelists that if a director has access to UPSI, but before publishing this UPSI to public, director resigned from the company and appointed in a competitor company as a director, there are high chances to leak or publish this UPSI intentionally or unintentionally by such director. In this case, what remedies or what actions should be taken by the first company from which the director has resigned?
So I can just give you my initial thoughts, and then I will leave it to Pritesh and Sudhakar also if they want to add on. It doesn't make a difference whether the person is resigning, the person is inside, the person is outside, doesn't make a difference. Because what did we see as part of the connected person? What is the definition of a connected person? Even if you resign, what you say, if you have UPSI, it is a self-test everybody has to undergo. When you have a UPSI, the regulation 3 says thou cannot communicate. And here is where I wanted to tell, India is gone far ahead from even US. In India, mere communication of UPSI is violative of the SEBI PIT regulations. Even if the opposite person has not traded, doesn't make a difference. The trade is not a prerequisite for SEBI to prosecute you. What happened in the WhatsApp group with Pritesh had mentioned as part of his presentation. In WhatsApp group, if you are going to be part of a WhatsApp group where UPSI is communicated, you yourself can be prosecuted because you are procuring UPSI through that WhatsApp. So neither can you communicate. You doesn't make whether you are in a competitor. Let's get out of all the syndromes of he's joining a competitor. He may not have joined anywhere. You cannot communicate UPSI pertaining to the company. Neither can you procure. So trade is a subsequent event. Even if you do not trade, if you merely communicate a UPSI, as a company secretary, suppose you know the company is coming out with a bonus. Are you saying that you have 1,000 designated person? I can go and tell all the designated person because they are anyway DP. Answer is no. Because there has to be completely breaching the asset test of need to know. Only if you breach that, you can. And Sudhakar has, as part of his 345, made a mention clearly. What are the exception to communication is only 3. If it is legitimate purpose, if it is in furtherance of your legal responsibilities, only then you can communicate. Otherwise, you cannot. And mere communication will take you to the wrong side.
And only one point to know what Narayan has mentioned is that the participants should understand one thing. It is not the company secretary who is regulating the designated persons or insiders or connected persons. Regulator is SEBI. Or till the time you are in the company, you are a designated person, your trades are getting monitored. The moment you are out of the company, that doesn't mean you can do anything and everything. Always you are getting regulated by the SEBI, and SEBI can always take the action against you. If you are communicating the UPSI, what is available with you, or if you are indulging in any trading activity of the securities of the company when the information is in your possession, or you are procuring further information from the company after you are leaving the company from your colleagues, all these things will get into definitely you into trouble.
Correct. And technically only one thing is that as per going by the regulation, even a person resigns 6 months, still he is deemed to be connected person.
Yeah. Thanks. That's a good.
Yeah. Thank you, sir. So the next question is for Sudhakar, sir. Whether PIT regulations applicable to companies which have listed their debt securities, but their equity shares are unlisted.
Yeah, this was actually several professionals were under a wrong impression that PIT regulations are not applicable to the companies where only debt securities are listed and that their equity is not listed. PIT regulations, if you see that, it is applicable to the listing of the securities, and debentures are falling under the definition of securities. That's why if you see the guidance note very clearly and comprehensively, we have given that even if your company is a private limited company, if you are issued debt securities and those debt securities are listed on the stock exchange, you are supposed to comply with PIT regulations.
Thank you, sir. So the next query is for Pritesh, sir. Sir, is trading include pledge of securities as well?
Yeah, so if you see the definition of trading, it's not only buying, selling, subscribing, it also uses the word dealing. And dealing is a very inclusive, and it includes all type of acts, whether it is based on consideration or not. So even pledging, revocation of pledge, transmission of shares, even gifting has been taken as trading in securities.
Yeah, thank you, sir. I would like to take use of Narayan sir also on the similar queries. That, sir, what is the difference between trading and dealing in the context of PIT regulations?
So, as Rakesh has mentioned, what is the legislative note of like this will be a regulation where it has clauses as well as note. As you're aware, under the parliamentary mandate, you have 12 to 15G of the SEBI Act, which talks about dealing in securities. It is widely defined the term trading to include dealing, because trading and dealing need not dealing. Trading, the definition comes within its ambit, the term dealing, correct? And as Pritesh had mentioned, that dealing is much, much wider. Whether it is buying, selling, or subscribing is direct trade. But even if you are merely gifting or a transmission or some transaction without even a particular value, This will come within the purview of dealing, and hence, in spite of having many representations to SEBI, where industry had made that pledging of shares, if it is coming within the purview of dealing, it does create a problem, because if you have pledged a particular shares and if you depledge, it cannot be done within 6 months. And suppose if you find another bank or an institution giving you a better, you will have to really wait till a period of 6 months. Similarly, if you have repaid the money and you are removing the pledge, and if you have just done an opposite transaction, you can't even do a depledge. So there were practical difficulties which industry had, but SEBI has been very clear that pledge is also going to be considered as a trade. And he had specifically mentioned whether it is pledging, gifting, transmission, whichever way there is dealing in shares, it will come within the purview of trading.
In fact, Rakesh, I want to just add one more thing what Narayan said, that pledging and depledging, that amounts to contra trade.
Yeah, that's right.
Yeah.
Suppose you are having your shares that you are from one DP to another DP you are transferring, even that also. So that this question also we have dealt with very aptly.
Yeah.
Thank you, sir. Sir, my next query is to Sudhakar, sir. Sir, is sharing of financial results for newspaper will be considered as sharing of UPSI?
See, when you are sharing the information in the financial results of the publication, but before you are giving it to the newspapers, what you have to do is first and foremost thing you have to share with the stock exchanges. The moment you share the financial results with the stock exchanges means you have disseminated the information publicly. After that only you can give it to the newspapers. Suppose without sharing with the stock exchanges, if you have given to the newspapers, definitely there is a non-compliance is there. You have shared the UPSI with the newspaper agencies. Same is the case with the media release also. Media release, first and foremost thing is you should not give it to the investor, analysts, or even to the media. First and foremost thing is media release, you have to give it to the stock exchanges. That amounts to public dissemination. Only thereafter you can give it to the analysts or to the electronic media or print media, whatever it is.
Yeah, thank you, sir. My next question is to Pritesh, sir. Sir, at which stage of the tendering process it can be ascertained that the UPSI came into existence?
So, tendering process is basically, it's a very long drawn process, and it involves various stages, and it would be very difficult to lay down any parameter, as to where in the information in a tendering process would become a price sensitive information. So it all would depend upon facts and circumstances of a case to case basis.
Yeah, thank you, sir. Now the next query is for Narayan, sir. Sir, does it permit the listed subsidiary to share its accounts with the listed holding company before the subsidiary's boards of directors approve the same?
So, as you're aware, today you will have your policy for legitimate purpose, and if the holding and a subsidiary company, whichever is listed entity or both of them, if they have similar clauses, we always recommend that at least put as part of your legitimate purpose policy, then subsidiary is free to share its accounts with the holding company and can procure accounts pursuant to, and the holding company can also procure it through this policy. Even if you have not put it, and if you are a holding company, you will still come under discharge of legal obligations clause, and you will say that if I have to, as a holding company, if I have 100 plus subsidiaries, and if I have to give consolidated financial results on a quarterly basis, so what we call FFC, all those results which come to the accounts department of the holding company for FFC, which is for fit for consolidation, those are in discharge of the legal obligation, and hence receiving such information will come under the exception provided under the regulation. But this I will give only with one caveat, that the information will have to be used for the purpose for which it is received. That means if I am at the holding company, The accounts department can use it only for the purpose that only for consolidating the accounts, only that amount of information. They cannot suddenly use it and compile it as an MIS and start circulating to everybody or asking or giving it to people. If it is even for legitimate purpose, it will only be for the purpose for which it is. So hence, in this particular case, Rakesh, if you're saying if it is for consolidation purpose, yes, even if it is ideally, both should have this. If they are either of the party, whoever is listed, please put it in your legitimate purpose policy and go ahead and do it. So long as you're using it for consolidation.
Thank you, sir. Thanks for sharing your views. Then my next question is to Sudhakar, sir. Sir, consequent to SEBI share-based employee benefit regulations, companies are granting various kinds of share benefits other than stock options to their employees, such as stock appreciation rights. Is PIT regulation applicable to such stock appreciation rights as well?
No, to my knowledge, I don't think PIT regulations are applicable to stock MSRs. The reason being, in case of stock appreciation rights, there is no question of issue or allotment of any shares there. And there, similarly, the designated persons, they are not selling or buying anything. Whatever the appreciation is there, that is only they are getting it. So, according to me, PIT regulations are not applicable to stock appreciation rights.
Yeah, thank you, sir. Now we will be having the last one question each for the panelists. That my next question is to Pritesh, sir. Sir, as you know that in terms of companies where preparation of financial results is going on, they require to share various kind of UTSI with the statutory auditors. So is it necessary that every time that information shared with the statutory auditor, does it require to be recorded in the structured data database, or what is your take on this?
So I think, one-time recording of such details in the SDS, that is structured digital database, would be sufficient with the period of sharing till the information becomes public. So it can be shared in a DDMMYY format till the publication of results.
Yeah, thank you, sir. So the next question is to Narayan, sir. Sir, how to interpret the term promptly for disclosure of information under Regulation 8 of the PIT regulation?
So, as you're aware, under even Regulation 30, you say that events which require disclosure must be disclosed as soon as possible and not later than 24 hours from the occurrence of event. In fact, many of the people, they take as if you have 24 hours, you have to disclose it immediately, promptly, and the 24 hours is given only as an outer limit. Now let us go to PIT regulation. The disclosure, they say, must be made promptly. So then you will have to go base about the basic definition, whether it is a Black's Law dictionary or your Oxford dictionary. What does prompt mean? What does it mean? Which means, is it ready? Is it quick to act? What is the occasion demand? And it can be said that once information becomes concrete and credible, it will have to be disclosed to the stock exchange immediately. And the 24 hours will be only an outer limit where you will have to really prove there were constraints, there were restraint on you that you could not have done immediately, and hence you use that 24-hour. But you cannot use 24-hour window by default. You have to do it promptly. The moment you get the earliest available opportunity, you should do it.
Thank you, sir. Thanks for sharing your valuable views on it. Sir, the next and last query to Sudhakar, sir. Sir, should the compliance officer get a non-disclosure, non-trade agreement signed when a designated person is resigning as full and final settlement?
Yeah, he should get it. He should get it a non-disclosure agreement. He should get it signed, whether the person is not only at the time of resignation, even at the time of retirement also. If a person is getting superannuated, because the resignation of a word includes also the retirement. So that should be there, definitely, that compliance officer should take it.
Yeah, thank you, sir. Thank you. We have completed, I think, all the questions which we have received. And majorly all the things are covered by all the three eminent panelists in their presentations, and further queries which we have received from the participants. And I request each the panelists to kindly give your closing remark in 1 minute time. So that would be to conclude the session.
I will start with Mahaguru.
Okay. So I'll only make a mention that even there was one of the questions about promoters dealing in shares. All I want to say as company secretary, you have to raise the bar. You are the compliance officer, and you have to be much more holier than thou. Okay. So if while you are doing every bit to set processes, trading window, specifically in this regard, you should yourself ensure that you completely refrain yourself from trading. Otherwise, you will be setting up a wrong. And hence, as I said, please ensure that irrespective of whether it is trading window closure, not closure, stay away completely from the stock of not only your company, but also your entire group companies.
Okay, Rakesh, from my side, in Hindi में एक मुहावरा है, सारी खुदाई एक तरफ, जोरू का भाई एक तरफ. So if I take that, and inference from there, all the laws are on one side, bit regulations are on one side. As far as the compliance officer is concerned, the amount of arduous responsibilities which have been entrusted upon the compliance officer, it is really a person who knows it, the real sense of the bit regulations. According to me, he should have sleepless nights. If the company secretary has to have a sound sleep, he should have robust systems in place. So my advice to every company secretary who is the compliance officer as far as the bit regulations are concerned, please ensure that proper, robust policies are there in place. Your department is completely sensitized as far as the compliances are concerned. At the same point of time, periodically sensitize all the designated employees on the do's and don'ts from time to time, especially the senior people. Sometimes it may so happen the compliance officer in the hierarchy, he may not be at a very senior level. Because several times this question is posed to me that, sir, mera koi sunta nahi hai. But unfortunately or fortunately, when God forbids, if something comes with the SEBIs, is going to take the company to task. That point of time, compliance officer is the first person who has to face the heat. That point of time, nobody listens to you. So you have to have your own ways and means, how you will ensure your compliances and how you will be able to discipline your people.
So I echo Mr. Shankar and Mr. Sudhakar's view on this, and the regulatory regime on, especially on a blue collar, white collar type of crime is just, regulatory oversight is just increasing. So it's very important to have not only a policy in place, but ensure that it is implemented. There should be a test check of this. There should be internal vigilance function, which cross-checks the trades done, especially by the designated person. Because any breach here, it's not only at individual level, but it's also at reputational risk to the firm in which that person works. So personal as well as organizational level, reputational risk is also there. So it has to be taken very seriously, and ensure that proper guidelines and regulations, especially this guidance note, is a treasure beyond measure. Everything is put up there, and anybody who's starting a job as a compliance officer must read this, and he'll get 99.99 all answers he will be able to get at one shot.
Yeah, thank
you. Before you conclude, on my behalf and my behalf of Narayan and Pritesh, who are other my co-panelists, I thanks ICSI once again from the bottom of our heart for taking this excellent initiative of organizing the Secretary Standards Week. And at the same point of time, I also take this opportunity to thank all the participants for posing such an excellent questions, and virtually to you also for grilling us appropriately from time to time. Thank you very much.
And gratitude to you, Rakesh, because you've been really, as I've been mentioning time and again, you have been the backbone for the core group. We dump actually what is guidance note. We are merely dumping every question which we get directly or at ICSI or at WhatsApp. It comes and dumped at you in a very unstructured manner, I've seen you making it in a structure with Companies Act, all the relevant provision, and make it so easy for us to deliberate and debate it. Kudos to you and the entire Secretariat team.
Thank you, sir. Thank you so much. Now it's my duty that on behalf of ICSI, extend a very sincere thanks from the bottom of our hearts for kindly this session and apprising and enlightening all the participants about the various nuances of the PIT regulations, and at the same time also propagating and advocating the guidance note which is issued by the ICSI with the efforts of all the stalwarts of the expert group on sectoral standard, and the kudos to all the actually the members of the expert group who are behind this guidance note. Thanks to you. Thanks to you, sir.
Thank you. Thank you.